Hi, welcome back to Finally Revealed. In this episode, I want to talk about the United States Supreme Court. We have some action in that area right now, and it seems timely, and people have questions. The United States Supreme Court is established by the United States Constitution. Article 3 establishes a federal judiciary. Have other videos set out, and I'll put the link below, about the state court versus a federal court that kind of explains that whole system a little bit better. Contrary to, I guess, some popular belief, you can't just walk into the Supreme Court and have them resolve a dispute, and likewise the members of the Supreme Court can't sift through prior cases and decide what they want to change. Cases come up to the Supreme Court by appeal from the U.S. Federal Circuit Courts of Appeal. They have numbers, and each circuit covers a couple of different states. And then we have what used to be the Court of Claims, which is now the U.S. Court of Appeals for the Federal Circuit. And so it doesn't have a number. And then, so that's the next layer below the Supreme Court. And then the bottom layer in the federal court, they probably won't appreciate that, but the basic level is the U.S. District Court. And some states are their own district, and some states have multiple federal districts within their state, but that is the place where you start in federal court. And those are the Article 3 courts, and Article 3 references back to the Constitution. The United States Supreme Court is the appeal court of last resort. So you start in the district court level, then if you lose there, you appeal to the U.S. Court of Appeals for that district, for that area over the first district court, and then you can go up to the Supreme Court for civil or criminal cases if the court accepts your request. And you make the request by filing a petition for a writ of certiorari, and that is completely discretionary by the Supreme Court. They can say no thank you, and then the decision that you last had is the final decision in that case for those parties. There are about 7,000 or 8,000 cases that are appealed or that are sought to be appealed to the Supreme Court every year, and they take 80 to 150 cases, and then not all of those get oral argument. So there is a process. Now, there is another way to get to the Supreme Court, and that by appeal, and that is by a court, the final court of last resort in the state, which would be a state's Supreme Court. And then those cases can be appealed over into the U.S. Supreme Court. There are cases that can be brought in the U.S. Supreme Court at the very beginning, and those are cases that involve conflicts between the states and conflicts between ambassadors or consuls. And so that would be the place that they would start out filing their case. Each of the individual justices is also assigned to different federal districts. So if you hear about someone in a death penalty case asking for a final appeal or to set aside their conviction, that is not going to go to the whole Supreme Court. It's going to go to the justice that's assigned in that area, geographic area. They will work with their law clerks, review the briefs, and send out a decision. Now, having the court start out with the Constitution, you need to fill the court. And so we go back to the Constitution. In Article 2, where it sets out the role of the executive, who is the president, and it sets out what the president can do, and the president can make the nominations for vacancies on the Supreme Court. They can do this both when the legislative body, the Senate, who has the right to consent and approve of the nomination before the person becomes one of the justices. So the president, if there's a vacancy, they don't have to wait for the Senate to come back and reconvene. The president can make an appointment during that period of time when there is not a Senate in session. However, that's a temporary thing, and then when the Senate reconvenes, they go through the process. When the Senate is in session, then the president submits a nomination for a candidate to fill a vacancy on the Supreme Court to the Senate. Then the Senate deliberates and decides thumbs up, thumbs down, and reports back to the president. If the Senate approves the nomination, then they send back documentation, and then there's a commission issued, and the person becomes the new justice on the Supreme Court and takes the oath, and then is there as long as there is good behavior. That's what's set out in the Constitution. Generally speaking, it means this is a lifetime appointment. And when we talk about Article 3 courts, those are lifetime appointments. It's until the justice resigns or dies. The only way to remove them once seated is by the impeachment process. So it's an important position to fill, and a lot of thought goes into it because the court can affect public policy and the interpretation of the laws going forward. It's interesting that when the writers of the Constitution set out how the court would be constructed, they put another power over to the legislature, which was to decide how many will be on the court. So the Constitution does not say how many are on the court. Now, right now we have 9 justices on the court, and it has been that way for a long time. The last time that Congress enacted the Judiciary Act, it was 1869, and that's when it established 9 justices. Before that, it fluctuated. It was as many as 10, and it was as few as 5. Now, an interesting fact, there's only one U.S. president who did not nominate or seat a Supreme Court justice, and that's Jimmy Carter. All of the other presidents have either had a nomination submitted to the Senate that was either then voted on and approved while they were still in office, or they submitted a nomination and then that person was approved after they left office but on their initial nomination. And then there are other presidents who didn't submit a nomination but had someone seated from their predecessor during their term. So Jimmy Carter's the only one so far who didn't have any Supreme Court activity during his presidency. It's interesting to note that the Constitution provides that there will be a court who will nominate people to serve on the court, what body will create the size of the court by number, and what body will approve or reject nominations. It doesn't set out the qualifications required. There's not any requirement of age, education, or birthplace. So there is also not any requirement that the president have a particular reason to nominate a particular person. There's also not a reason that the Senate must give to reject a particular person. So how the procedure works is the president submits a nomination, the Senate that follows its standard senatorial rules and reviews the application. Originally, they just reviewed it on their own, took a vote, and submitted their response. Later on, it was decided that while their discussions didn't need to be in public, the vote needed to be disclosed, and so the discussions were in what is called executive session, which is any time an official government body has a closed door meeting. Usually exceptions in everyday life would be they do that when there's a personnel decision, or when there's some sensitive material, or when there is some confidential communication from attorneys or other professionals provided to them that they are then reviewing. So those are closed door meetings away from the public. However, they made the rule that when the senators vote, then that vote needs to be recorded. So you can go and find the votes of your senators over time and how they voted on the various nominations. And that's recorded in the Senate's executive journal. They must all be by voice vote. So next, we have, since there's no educational requirement, what is the history of the court? Well, the history of the court is that the last time there was an appointee who had no legal training. Now remember, when the court started initially, there were no law schools. So people had studied law by the Old English method, which was to show up in court and watch the trials and record what happened. Then we had the reporting system where there were independent reporters who took the transcripts and the decisions and started publicizing those into what we have now as our law books, and then law schools were created. So the last two appointments were 1941, which was the last time that we had people who didn't have a formal legal education who were elevated to the Supreme Court. One of these people did not graduate from college, but did graduate from law school. The other person did not go to law school, but did pass the bar. So since 1941, all of the nominations and all of those who were seated on the Supreme Court have a legal education and degree. Now, in keeping with our no rules policy, we think about what the discourse is for, the examination of the candidates and inquiry into their background, and a lot of them are justices that have worked their way up through the federal judiciary, so there is a body of law, so to speak, that they have created through their decisions. Now remember, the courts do not make law. The legislature makes this statutory law and actually writes the written laws. When people talk about the Supreme Court making law, it is case law because the court interprets the laws. And so it is through those interpretations, if the legislature does not like the interpretation, that a remedy is for the legislature to go back and rewrite the law and say, no, that's not what we meant this. And so that's how those two bodies work together. It's easy to think that now we are in a more contentious society, but actually over time and looking back at history, there was some bad fights and all kinds of wrangling back all the way back to Lincoln, back to Andrew Jackson, where there was partisanship, there were favors, and then Franklin Delano Roosevelt ushered in the new partisanship debates over the Supreme Court when he was president. Of course, he was president longer than anyone else. Now, also no provision for the nominees to be testifying before the Senate Judiciary Committee or the full Senate or anywhere else. The first time that happened was 1925. And then it didn't happen for a while, and then it happened here and there based upon some particular real or perceived bias or some other issue that they thought that the senators thought they needed to delve into. And then ever since 1955, they have all come in and been questioned. And then, of course, we have Clarence Thomas, who was the first and so far only Supreme Court Justice who was asked about his personal private life. So I thought this was interesting and it was worthwhile. If this was interesting, if you learned something, give me a thumbs up, share it with someone who might have an interest in this or who has their own idea of how this all happens and plays out. Subscribe to see the other videos and come back and see me next time. Thanks for watching.